gun rights lawyer Alan Beck on how his oral arguments against Hawaii's vampire rule went at the Supreme Court. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis. This week, we are taking a deep dive into what it was like in the courtroom as the Supreme Court deliberated over its latest Second Amendment case, Wolford v. Lopez. To do that, we actually have one of the attorneys in the case, the attorney for the plaintiff, Wolford, against Hawaii's gun carry restrictions that people have taken to calling the vampire rule, which flips the default to make it so that anyone who's legally carrying must get express permission from a property owner before entering publicly accessible private property. At least that was the core issue of this case. And that man's name is Alan Beck. He was the lawyer, and he's with us again. We had him on a couple of weeks ago before the show, and before the big show, I suppose you could say, before the oral arguments here. And now we're having him on to go over how he thinks it all went. Welcome back to the show, Alan.
Hi, Steve. Thanks for having me on.
Absolutely. Appreciate you doing this and doing a bit of a post-mortem, so to speak, on these oral arguments that just wrapped up this week. You just got back home to California, right? And I think you've had a couple of days to process how it all went. And I think, you had a different perspective than I did. I was listening live, but I wasn't in the courtroom. I've read the transcripts, but I didn't see how the justices' expressions changed throughout this and what their body language was saying in addition to their words. So, obviously you're an interested party in this case, certainly, but you have a bit of a unique perspective on how it all went down. And so I just start off there. How do you think you did?
I think the case went well. The justices seemed to be sympathetic to our case, largely because they just decided Bruin a couple years ago, and in Bruin, the court found that you have a general right to carry in public spaces, and the vampire rule. The reality is, it is designed to make it so that you can't carry in most public spaces. And what the vampire rule does is it says that you have to receive affirmative permission to carry on private property that's open to the public. And that includes a gas station, a mall, laundromat, any sort of place that is private property you typically would go to during your day-to-day business. And the reality is this law, most businesses are not willing to take a position one way or another on whether you can carry a firearm on your property. It's on their property, I should say. And there are most business owners I've spoken to, and we had quite a few that were willing to submit declarations, have all told me the same thing. We care less if you carry. In fact, a lot of us support it. We just don't want to take a hit on our profit margin by taking a position on a very politically contentious issue in this country. And the justices appeared sympathetic to the argument because, assuming most businesses are not willing to put up a sign, how often are your rights going to be restricted if you go to private businesses every day? I know that I spend, on any given day, I'm at half a dozen private businesses to get some coffee, to get gas, go to Costco, go to the gym. And because of that, the reality of the impact of this law, that eviscerates the right that the Supreme Court just found is protected just a couple years past in the Bruin decision. So, based upon that reality, it seemed the justices thought that, this is a law that's unconstitutional.
Okay. And so your impression being in the courtroom, which I think I shared this impression listening live and reading transcripts is that your case went over pretty well with the majority of the court. Um, Now, actually, one of the things I wanted to start off with here is it was pretty long oral arguments, right? Every single justice spoke, and this went on for almost 2 hours. That's not normal, right? Like, how did that feel in the room? That much, longevity of argument, and then also with apparently quite a bit of interest from every single justice.
Well, it was honestly very taxing. I was speaking for a bulk of that time, and for the rest of the time, I'm trying to stay focused on what everyone's saying because, of course, I ended the hearing with a rebuttal to what my opposing counsel was saying, and then the federal government was also there arguing on my behalf. So obviously, I stayed keenly interested with to what they were saying. So just the amount of time, took up a lot of my mental faculties. And it
Because
I
usually it's only about an hour that they do these oral
That's
arguments,
correct.
right?
The
Yeah.
argument was there was an hour of argument scheduled, and it took when it's all said and done, there's also time getting there, just sort of waiting around for stuff to happen, right? So, you're sitting in that chair for well over 2 hours, Um, so, and it seemed to me that, all the justices have a lot of interest. Something that I did notice is that questions tend to be tell you where a justice's head is at.
Hmm.
And there seems to be, there's I think that a majority of the court agrees this law is unconstitutional, but I think there's varying approaches to the methodology that the justice would like to take, and that's why he got questions from every single justice. I think if they went into it with, 5 or 6 of them thinking this is the way that we're going to do this, and this is clearly unconstitutional, then you wouldn't hear as many questions. But because I really think that there was a majority of the court that was in agreement this law is unconstitutional. But what I suspect is some of the justices were, well, we'd like to do it this way. We think this is more important, and there's some disagreement there. There was so much question of each of the justices because they want to flesh out the legal theory, is behind this case.
Yeah, I mean, it's still really a brand new area of law for the Supreme Court, right? They really haven't done a lot of litigating on the Second Amendment in particular. The first big case wasn't until 2008, right? That was the landmark Heller decision. Bruin itself was uh, the next real follow up major case, and that didn't come until 2022. And there's really only been, what, five Second
I
Amendment cases?
this
So
is
this is
the
the sixth one.
No, this was the fifth
But this
case
is the fifth.
and
Okay.
that's been argued. There's been um, you know um, a couple cases that the of the cases have been argued. This is the fifth one, and there's been a few other
Yeah.
minor cases that where they
Yeah, it
decide on.
depends on how you count it, right?
Yeah, but
Miller,
yeah,
Heller, McDonald, Saitano, I think the
yeah,
stun gun case, which was obviously
yeah,
something
yeah.
that you worked off a lot of. Then so that's four, and then Bruin is five, six is Rahimi. So I guess you could say seventh. The point is,
No, I mean Saitano and Miller
it's
weren't
not a lot,
argued. Yeah, Miller and
right? They weren't
Saitano weren't
argued.
argued.
Yes.
So so fifth in terms of argued cases. So, and anyway, I mean, any way you crack the eggs here. This is not a big body of law right now.
Hmm.
And, I mean, because that, unlike, say, a First Amendment case where, there's literally hundreds of cases that, it's huge body of jurisprudence. The Second Amendment, it's in its early phases. So a lot of the big questions have not been answered yet.
Yeah, and so that probably explains perhaps why the oral arguments were so long in this case, why every single justice, including Thomas, who's notorious for not speaking very often in oral arguments, chimed in with their own questions. And did it feel like in the room that you could tell body language or whatever that all the justices were particularly engaged in
Yeah,
thinking through these
absolutely.
issues?
That was maybe the most surprising part of the argument is since I was in the courtroom and not just listening to a live stream of the audio, you could see there was, if the justices liked a question or a response, there'd be certain mannerisms. Maybe you could see the justice physically lean over in interest, or um, lean back if you could tell he thought, this wasn't particularly, it was something he didn't like, and you could the body mannerisms itself, even if there was no audio at times, could tell you everything about how a justice was thinking. So
Yeah.
that was something I really appreciated. I had never been to a Supreme Court argument prior to this. I had no idea uh, what it looked like inside. So I really learned a lot just from being in there. Yeah, and I think that even if you're someone that has no plans of ever arguing in front of the Supreme Court, if you're in DC, that it'll be really worth it to attend a hearing just so you could see how much is going on in the interplay between the nine justices in person that just isn't captured in the audio.
Interesting. And so, obviously you've argued in front of a lot of federal courts, federal judges before, including, at the Ninth Circuit, at the highest levels of the Ninth Circuit. But for you, you felt like it was a different experience in front of the high court here.
Yeah, I mean, there are similarities between this and arguing at appeals court. There's more similarities than are differences, but the format's a little different. It's actually a little bit more intimate because you're very close to the justices, and there's a little more of I- you really can tell a little more that the interplay that's going on between the justices. Whereas I think, at least on the Ninth Circuit, I think a lot of times they're trying to keep sort of a unified front.
Interesting.
So um, yeah, it definitely was a unique experience in that. I mean, it's just it's hard for me to convey how much was being conveyed through body language.
Hmm.
That
Were there any particular moments that you can think of, specific, instances of a justice reacting in a certain way that gave you some insight beyond their words, what they might have been thinking?
there was one point where Justice Alito, and I just can't remember exactly the line of questioning, but you know, I, I believe it was when we were discussing some of the historical analogs. He just, he put one of his hands to his face, and it just, you could tell that he just didn't quite, he wasn't buying the argument, you know, and there, um, and it's and honestly, I mean, just sort of an aside, as a lawyer, you see these people on TV, and it, it's very, it it took me a little bit to get in the groove of I'm in court. I've done this 100 times. I'm seeing these guys looking down at me that you see on TV. At the end of the day, you just need to be the lawyer that you are. And, you know, doesn't matter if you're in the highest court of the land. This is, you have to, just go through, you know, behave like the lawyer that you are in an appeals court. I mean, this is, you have to, it's so it took me a little bit to stop being starstruck. Is
Mm,
maybe what I'm trying to say. Yeah.
right. Yeah, and it makes sense. These are uh, the best known lawyers in the world, in the world, right? These justices. So that makes sense. Was there uh, speaking of like your ability to pick up on body language that those of us, watching from home couldn't, listening from home really, or reading transcripts couldn't necessarily get to. I know there was a moment you were going back and forth with Justice Barrett discussing um, the how far, I guess, your view of the Second Amendment stretches when it comes to carrying a gun legally onto private property, and how much protection you get from the Second Amendment. There was there was back and forth where she asked you about, what about residences? What about places that aren't publicly accessible? Does the Second Amendment right extend there, or would it need to go through the same sort of Bruin historical test that you're doing with this publicly accessible private property? And you said yes, and she seemed surprised at that. But it seemed like you were able to work through it with her to explain your view of that, um, and that perhaps she. I mean, it felt like in listening to the oral arguments and reading the transcript that perhaps she came around to understanding your position better. First, she didn't understand it, and then later did. Did you get that feeling from her?
Yeah, absolutely. I was glad that she gave me a opportunity to clarify my position because here we're dealing with private property that's open to the public. So the government, my position is the government needs to be able to cite to other laws that restricted private property that's open to the public in a s- similar manner. And the same, I think, applies to a private residence in the sense that, here, my overarching point is that when you're carrying a gun, it implicates plain text of the Second Amendment. And pursuant to Brune, that means the government needs to be able to cite to a American tradition of relatively similar firearms law. So that's going to be a different tradition when you deal with private property open to the public than private property that's not open to the public, like private residence. And um, but my point is that the government, it's still on the burden is on the government to make that showing of history. And the reality is, it's probably a much easier showing for a private residence than it is for private property open to the public, where that history just simply doesn't exist. And
Right. But
after
she seemed a bit surprised at first to hear that you do think the Second Amendment right extends to this, but then eventually working through it,
yeah,
it felt like she understood. Did she seem
right,
surprised and then seem
she
to
she
accept what you were saying?
she seemed surprised, and honestly, I should have been a little more clear in my initial answer. I was making the statement that they cannot ban public carry, carry in a private residence based upon the record that's been established in this case. And and later I was Justice Barrett gave me the opportunity to clarify that I'm just talking about the record that's been established in this case. And in another case that does not deal with that deals with private residence, where they'd amassed a different record, then it might be constitutional for them to ban carry.
Yeah.
Once I
And from
got
your
that,
point of view, it felt, yeah, once you got to that point, you felt like
yes,
she
yeah,
understood it.
yes, absolutely. And I think there's something that also teaches us is that it's pretty clear to me that Justice Barrett does not view a default rule on private property that is not open to the public, like private residence, as being unconstitutional. So there were a lot of people after Brune that you know told me that I was being a bit of a downer Debbie, but I said I don't think all the gun laws are going away, and I think this is evidence that there's at least one of our conservative justices does believe in the propriety of some firearms laws.
Yeah.
And
And they probably all do. It would
no, yeah,
seem like.
absolutely. I mean, there's
Yeah.
some level of gun control that is part of our nation's history. That's just the reality. And, we need to work within the confines of that. And we need to work within the confines of the justice's, predisposition towards certain laws. It's, at the end of the day, history also needs to be interpreted. And, that's through the eyes of the individual justices if a case gets up there. And, it's, I think that, that shows us that there definitely is a way forward after Byrne. Things have gotten more favorable for the Second Amendment. but still, there people should really think about the cases they're filing and maybe do a little bit of preemptive research, see if what they're about to file is something that arguably could be justified through history. At least through the lens of at least certain viewers.
Yeah, makes sense. And yeah, I do think that Barrett's that back and forth you had with her does suggest exactly that. But speaking of arguments that and how they felt to you in the room, what did you feel was your most successful argument? Like, what did you feel when you were up there going back and forth with the justices that had the most purchase with the most justices?
Well, Hawaii cited to black codes to justify their default rule or vampire rule. And for those, um, a black code is a law that was passed after the Civil War by some of the southern states, maybe all the southern states, which were only applied towards African Americans. So in this case, the Hawaii cited to a law that is very similar to a black to the default rule in some senses, in that the an African American would have to get permission to enter the private property of another with a firearm. And I don't think this applied to private property open to the public in Louisiana at the time. This law was out of Louisiana, but there's some debate on that issue. But even if you accept that this applied to private property that was open to the public, this black code, then I still, I argued that it doesn't really matter because a racist law like this shouldn't be cited to in 2026 to justify a gun law. It's a really bad part of history. It's that only dealt with a very small insular group that was being discriminated against. Its purpose to discriminate against African Americans rather than being a law of general applicability that applied to everyone. So, and I think the justices really endorsed my position. Are going to endorse my position, and I'm glad they are because to me, I just don't think that's a good thing we should be doing. I mean, we have some bad history in our country, and regarding how we treated African Americans after the Civil War, I mean, and prior to that as well, obviously. And that's not history that we should be embracing. It's history that we should say, be pushing away. And say, I was really surprised at why decided that we're going to rely upon that. In fact, Justice Kavanaugh was very critical, as was Justice Gorsuch, for relying upon this.
Yeah, yeah. They got a very critical reception of that, and I too was also surprised that they went down that path. It seemed like their weakest argument. And that were you? I was listening to it. I was pretty surprised to hear Neil Cattell, your counterpart, who was defending Hawaii, representing Hawaii in this case. He actually argued. Now, Hawaii had been arguing that this particular part of the Black Code in Louisiana wasn't racist, and that it survived Louisiana's admittance to the Union, and but he took it a step further in oral arguments and claimed that it was actually potentially beneficial to Black people in Louisiana, that it protected Black churches and Black-owned businesses in 1865 Louisiana. Um, were you surprised to hear that in court, and how did the justices react to that particular claim?
Uh,
Do you feel?
the whole Black Code argument fell extremely flat on the vast majority of the justices. Justice Jackson did have some sympathy to the argument, but I think she was the only one. I think that on that particular issue, 8 of the justices just are certainly disagree and are frankly most likely appalled at the use of those types of laws.
Yeah. And Jackson's argument, I'm interested in your thought on it. It seemed to me like she was obviously Justice Jackson does not like the Bruin test. She doesn't like the history tradition test. I think she takes probably a much more restrictive view of the Second Amendment, certainly than the conservatives on the court, and perhaps even than some of her other uh, Democratic appointees. And it seemed like she was trying to argue that the fact that this law should be relevant or could be relevant is a problem with the whole test, the whole history test overall. I don't know. What did you make of her argument? Do you feel like anyone else was being persuaded by that? Even Kagan and Sotomayor, did you see anything that would indicate they agreed
Well,
with her position on this?
Justice Jackson really wanted me to concede that the Bruin history test is unworkable. And, the black code was one example of that. And, that's essentially her asking me, should Bruin be overruled? I think it shouldn't come as a surprise to you that I did not agree with her proposition. And yeah, I think that's her overall arching theme is that Bruin is unworkable. History should not be solely relied upon. Therefore, Bruin should be overturned. And I think that I did not get any indication from the other two liberal justices that they are trying to at least push for Bruin to be overruled. I think that you know I think what potentially could be happening is Justice Jackson is planning on issuing dissent and laying a foundation for herself for down the road the um, if the conservative majority goes away and there's perhaps a realistic chance of Bruin being overruled. So
Yeah,
rather than her believing that in this case that's a realistic possibility.
right. Yeah, it does. I mean, that's how it feels. To be frank, most of the time that Justice Jackson is asking questions in these Second Amendment cases. Um, But yeah, so we talked about what you think the strongest part of your case was. What did you feel like was the strongest part of Hawaii's case? What did you think? As far as the justices' reactions go, that Hawaii had, their strongest argument, I guess.
Well, I think that the part that wasn't at least immediately dismissed and the justices wanted a little more argument on was the property law issue.
Mm, yeah.
Hawaii's one of Hawaii's major points is that this law isn't actually a Second Amendment case at all, and should simply be treated as a property law rights case. And I mean, the justice certainly wanted discussion on that, even though I don't think the majority of the justices were buying the argument. There at least there
Hmm.
certainly was definitely something there to discuss. Whereas with the black codes, that was just not something they were even really willing to entertain.
Yeah. Yeah. Beyond Justice Jackson's comments on it, didn't seem
There
like
was
there's a lot of purchase.
another issue, and this is something Sotomayor was asking me about, and it's hopefully your viewers when they watch this find this interesting, but it she had a question on a case called McKee, and one of the other points that Hawaii was trying to make is that there should be a state by state standard in
Mm,
determining whether you should be given permission. The crux of our argument is that you have an implied right to enter private property open to the public with a firearm, because that's been the historical tradition throughout our nation's history. That, if the owner doesn't like you carrying a firearm, then they can put up a sign or tell you, you know, uh, no guns. And Hawaii was taking the position that there should be a community standard approach to making these determinations. So the tradition of an individual state should be determined. And they were saying that Hawaii has never had a history or a custom firearms carry. Therefore, there's never been an implied right to enter private property open to the public. And one point, Justice Sotomayor asked me about a case called McKee, which deals with whether mussels in a river in Missouri could be harvested by, some guys were entering onto this private property that was open to the public. And, I just thought it was interesting that, here we are dealing with a case about firearms carry and just, the way the law just takes you into different paths. And somehow a case about whether you can harvest mussels in a bed, in a riverbed in Missouri is similar, I mean, it's applicable,
Yeah.
I mean, and
Right.
you wouldn't think at first blush that the two things have anything to do with each other, but the question there was uh, whether there was a custom of allowing people to enter into into private property to go harvest mussels, and from where that custom comes from at the state level or at a national level. And we had a bit of a debate on that. And it just you wouldn't think at this would be something that would be relevant, but I mean, it reminds me of in law school. Um, a lot of our property law, from where you can harvest minerals like oil rights, water rights, comes down from a case. I think it was Pearson v. Post, I believe, about two guys fighting over who owns a fox. Yeah, and the court found that a fox, because it's a wild animal, it was two guys are hunting, right? Well, one guy's hunting, and this anyway, the fox ends up on it's chased away, ends up on somebody else's land, and the court is says that a fox is a wild animal. It's it you don't have vested ownership rights just because it was on your property. If it runs off onto the other property, then it's uh, gets owned by that person. And similarly, and I'm not a mineral rights expert, right? So just sort of take this with a
Well,
grain of salt. But
my
like,
my mom is a fox hunter, so we'll, I'll have to tell her about this story.
it's oil, when it travels of its own volition, rather than being mined by a person, artificially moved onto other property, it just naturally travels onto it. It's like a wild animal, and
Hmm,
that other property owner now has ownership rights to it. It's like
interesting.
and it all comes back from two guys in the late 1600s fighting over a fox, and this entire body of jurisprudence has been built around these two guys. And I'm sure those two guys would have been shot. Similarly, we're talking about mussels in a riverbed and how that applies to handgun carry. And, maybe I'm belaboring this a little bit too much. I don't think people um, are logging on to hear about my views on foxes and mussels.
No, it's interesting the point you're making here, though, that and this gets at the core of the Bruin standard, right? It's supposed to look at the historical tradition and how we understand these things, going back to, especially when our standards, our laws were adopted.
Yeah, absolutely. And we have a common law tradition in this country. Um, a lot of European countries has something called a civil code tradition. And in fact, the civil code tradition is much more common in just around the country. And what that means is in a civil code tradition, they just look to see what's in the text, right? Um, they're not trying to build off previous cases and looking at precedent and stuff like that. They don't really have a concept of precedent, and so every case is a new case based upon this judge's interpretation of the text. And what I find what I find great about our American system of jurisprudence is, we're tied to history, we're tied to tradition. It goes back centuries, literally over 1,000 years, because we look back to England as well, and we look to see what our ancestors have done you know, and we're not trying to reinvent the wheel every case. We apply, we analogize, we look to see what's worked in the past, and that's what we're doing here in Brewer with the Bruins.
Right.
is
And the big dispute here, and what Sotomayor, I guess, was getting at, to draw it back to your original point, it was over whether it should be Hawaii's tradition in particular, even though most of that comes from its pre-American history, right? The Kingdom of Hawaii was what Cattell cited to a number of times to try and build this idea that carrying guns in public places was never allowed in the state. Whether that should be the standard or whether it should be, the American tradition, because Hawaii is now, I think, as you pointed out in court, an American state. It's part of the American tradition now, and that's, from your argument, that's what matters more than what the Kingdom of Hawaii might have
yeah.
done.
I mean, it's also Hawaii's argument ultimately for a Second Amendment purposes, just an unworkable standard too. I mean, if we accept Hawaii gets to use their pre-kingdom history, their kingdom history, and it's a state standard. That means the judges in Hawaii are going to have to conduct independent research just about Hawaii, right? And if it goes up on appeal, those judges are going to have to turn themselves into Hawaiian specialists. If there's a case out of Alaska, well, then the laws of the Tsar of Russia are going to be, we're going to have to look to see what the Russians were doing, because we purchased Russia, and I want to say we purchased Alaska from Russia in 1863, right? So this is right within the time for Hawaii's argument. The French tradition, and for everywhere we made the Louisiana Purchase, and I believe, was it Spain and Florida? I mean, you see the point I'm making. Oh, and then our territories. I mean, are we really realistically going to research the laws of the Chamorro tribesmen of Saipan and Guam to determine an American's firearms rights on, over in those territories? No, I mean, that's an unworkable standard. It also defeats the purpose of having federal law. I mean, at the end of the day, people have to recognize that the First Amendment, Second Amendment, the Bill of Rights are just another way of saying that this is federal law that happens to trump the rest of federal law, right? It's our highest federal law. And the whole point of having federal law is to have a uniform standard throughout the country.
And so this argument, right? It seemed like, listening to it, that perhaps Sotomayor and Jackson might be on board with this idea of using Hawaiian tradition and looking at this as a property rights case that can be dismissed at step one of Bruin instead of going into the historical analysis. Did you feel like any of the conservatives got on board with that? And then, perhaps more interestingly, did you feel like Kagan was on board? Because she seemed like she might have had a different view.
I don't think that she's on board. I think she sees the same issues because remember, I mean, you apply it here, then you start applying different constitutional rights. I mean, as the court said in McDonald, the Second Amendment isn't a second class right. So, right, I mean that makes it so that, I mean, it's
There's
cruel
a
and
lot of
unusual.
talk about that, by the way,
Yeah,
from like Roberts, especially, was very adamant about the
absolutely.
second class right conception when he was discussing in his time talking too, right?
Yeah, absolutely. It's like, I mean, this could, um, you start taking this concept, it starts getting absurd results. I mean, the cruel and unusual punishment clause, the Eighth Amendment. I mean, you're really going to let one state torture a person because that's part of their history and another not torture a person? I mean, you develop this community standard idea. I mean, it's just, it would create perverse outcomes. And yeah, so I just don't see the court, entertaining it, to be honest.
But so overall, I guess, on like where you felt in the room these justices were coming down, did you see like Kagan, the first two, the liberals, the just for shorthand here, right? Sotomayor and Jackson, they seem more willing to go along with, what you described as the Hawaiian argument that had a little more influence, I think, with the court. And they seem perhaps like they're going to rule against you. but Kagan appeared to be, at least from the transcript and the listening to it, at least more focused on the second step analysis. She was more focused on whether or not these analogs are good analogs to the modern law, right? And more focused on not the black code, but she didn't talk about that one. But she did talk about the anti-poaching laws from the founding, and she did say, well, it just sort of depends on the generality you take that approach. And I guess, do you have? There's been some suggestion, some people, including we have a gun rights lawyer from Minnesota's Gun Owners Caucus that wrote a piece for us named Rob Dorr. He thinks that Kagan might go your way. What did you feel in the room? Did you get that sense at all?
I will say that Justice Kagan didn't seem as openly hostile to our position. And, she probably still make up her mind, honestly. She could potentially join the opinion, a majority opinion, and make it 7-2 in a and potentially strategically so that she can get the court to narrow the ruling, right? If she's afraid that they're going to be more expansive, I mean, she could think that, well, it makes sense to join it and just make sure that's narrowly rules on why find to be unconstitutional.
Um, on that point, I guess. Well, one, did you see real quick? Most people have not raised the idea that any of the six conservatives might go against you. How did you feel any of them, Barrett or Roberts or um, Thomas or somebody might have might potentially go against you? You get that feeling at all?
No, not at all. I
Okay.
think that, after I answered Justice Barrett's questions, she seemed on board this law was unconstitutional. I mean, she was the only one that even had um, any sort of reservation. And after our conversation, she seemed to be pretty open to the idea that this law is just, a violation of the Second Amendment.
Okay. And so to your point there about tightening and scope of this opinion, what do you see as the most likely outcome after going through these oral arguments? How expansive do you expect this ruling to be? I mean, one, it sounds like you expect that they will rule in your favor, but the how far do you think they'll go with it? Do you think you expect them to answer any of the sort of lingering questions about how to do the Bruin test, including time, maybe this black code thing? They spend a lot of time talking about that. Do you think they'll incorporate that into their opinion, or do you think it'll be very narrowly focused on this is an outlier law, it's unconstitutional, these historical analogs just aren't close enough? How do you feel it's going to
I
come down?
think that the majority opinion will be the core opinion will be relatively narrow, and many of the justices will write concurrences.
Mm,
You know, um, that's just a prediction, but because it seemed to me that some of the justices, they we know it's unconstitutional. We're still trying to figure out exactly why, right? I mean, we know it is, but I mean, we have a general roadmap of why we think it is, but the the exact path we want to take within that general road, we haven't decided the exact lane we want to take within the road. We haven't
mm.
decided yet, and so there may be some disagreement, even though all the justices are on the same road. Not all of them are in the same lane. Is what I suspect we might discover. That's just a guess, though.
And that's been pretty common for the courts since Bruin, right? I guess there have only been two, right? Bruin and Rahimi, but they both featured a number of concurrences.
Yeah, I mean, you saw that. I mean, the Rahimi opinion really showed that it was a relatively short majority opinion. Then I want to say all of the justices that were in the majority wrote concurrences.
Yeah,
So
yeah.
I mean, we can see something very similar. And it's going to be very interesting to see what happens because Hamani is being argued in March. So I have a feeling that they're going to want to have this opinion out so that Hamani can incorporate something from Wolford. The court's gonna at least want to reference Wolford. So
So yeah, it could be a pretty quick opinion then in that case.
yeah, I mean, at least I really don't think we're gonna have to wait till the end of June. Is my point is because Hamani, which for your viewers that don't know, deal with whether a unlawful user of marijuana can lose his gun rights. Is that's being argued in March. They'll have to release an opinion by the end of June. So you'd think that they'll um, release an opinion, in Wolford, at least a little earlier, maybe June, and so they can, address what gets decided in Wolford, in
Mm.
that.
It would make sense. Keep the jurisprudence clean that way. Do one before the next one, but we have no idea if that will actually happen. I suppose,
Oh yeah,
right?
this is all just speculation on my part.
Yeah, yeah. But you are in a position to have a good viewpoint of what may occur here, and obviously, we really appreciate you coming on the show and giving us your insight into how these oral arguments went in person, and from your point of view, how you think the justices were reacting. Because I think uh, being in the room, seeing their body language, it gives you a little more insight than what we can get from just listening to it live or reading the transcript. So I appreciate you being willing to come on and answer the questions and give us your view of how things went.
Well, thank you very much, Steve.
Yeah, and for people who want to continue to follow along your work, you're independent. Sometimes you work with the gun rights groups, but you're an independent lawyer. You've done a lot of cases like this. It's your first Supreme Court case, but you've had a lot of other high-profile cases as well. How can people follow along with your work if they want to do that?
Well, I maintain a business page on Facebook. So if you just put in attorney Alan Beck, I update that. Attorney Alan Beck. Just follow that page, and I update at least a couple times a week. On what's going on with my litigation.
All right, great. And I'm sure we'll have you back on the show in the future as well, both perhaps for this case, maybe when the opinion comes down, but also for your numerous other cases that you're following as well. This is not your only Second Amendment challenge. So
Quite a few of them.
yeah, so
Yeah.
it's we appreciate you coming on and talking with us, giving us some of your time to get into the details of these cases.
Oh,
But yeah,
well, thank
that's
you, Steve. Yeah.
that's that's all we've got for this week, though. We appreciate you taking the time. And this will be out for Reload members on Sunday, as usual. They get a day early, and then everyone else will have access on Monday to listen. So if you want to become a Reload member, you can head over to reload.com, pick up a membership today. But that is all we've got for you guys this week. We will see you again real soon.
No, the devil's got no